Hello. Hello. Register. Register. Yes. Yes, thank you. A very good morning, dignitaries on and off the dais, esteemed colleagues, ladies and gentlemen. This is Professor Abdul Hakim, extending a warm and hearty welcome to you all to the late Hon'ble Shri Justice M.L. Pendse Memorial Lecture Series. Today's lecture will be delivered by Hon'ble Shri Darius Khambata, former Advocate General Maharashtra, senior advocate, and a very distinguished and renowned personality in the legal field. He will be speaking on a very interesting and important topic, basic structure doctrine, what it is and why it matters. Honorable dignitaries, ladies and gentlemen, last year, MNLU Aurangabad started this lecture series for the purpose of providing a platform for legal and intellectual discourse to the students, faculty members, and the legal fraternity on the whole. The basic objective of these lectures is to inspire young minds and motivate them through thought-provoking lectures by prominent legal luminaries. ladies and gentlemen, Honorable Justice Madhav Lakshman Pendse did his graduation from Wilson College, Bombay. After graduation, he joined the prestigious Government Law College, Bombay, to pursue law. He enrolled as the advocate of Bombay High Court in 1958. He practiced in the civil, criminal, and the appellate sides. His lordship was elevated as the judge, elevated as the additional judge of the Bombay High Court in 1978. And within 1 year, that is, in 1979, he was made a permanent judge. His lordship became the Chief Justice of the Karnataka High Court in 1995. With this, I request the dignitaries on the dais to kindly light the sacred lamp and pay floral tributes to late Hon'ble Shri Justice Madhav Lakshman Pendse. Thank you, honorable dignitaries. I now request Honorable Shri Justice Abhay S. Oak to kindly felicitate the chief guest, Honorable Mr. Darius Khambata, with a shawl, bouquet, memento, and a book. Thank you, Your Lordship. I now request Honorable Shri Justice Ravindra V. Guge to kindly felicitate Honorable Justice Abhay S. Oak with a book. Thank you, Your Lordship. I now request our Honorable Vice Chancellor, Professor Dr. Bindu Ronald, to kindly facilitate His Lordship, Justice Mangesh S. Patil. His Lordship, Ravindra V. Goge. Thank you. I'm so sorry. Madam, I also request you to felicitate Honorable Shri Justice Mangesh V. Patil with a book. Thank you so much. Esteemed dignitaries, ladies and gentlemen, now I request our Honorable Vice Chancellor, Professor Dr. Bindu Ronald, to make the welcome address. Professor Bindu, please.
A very good morning to one and all present over here for the Second Honorable Justice M.L. Pendse Memorial Lecture. As we are gathered here, as the Vice Chancellor of Maharashtra National Law University, Aurangabad, it is my privilege to welcome one and all to this memorial lecture. I take this opportunity to extend a very warm welcome to our Chancellor, Honorable Justice Abhay Oak sir, our chief guest of the event, Honorable Shri Darius Kambata, Senior Advocate and former Advocate General of Maharashtra, who will be delivering the Second Honorable Justice M.L. Pendse Memorial Lecture on an extremely important topic, the basic structure doctrine, what it is and why it matters. We also have on the dais Honorable Shri Ravindra Guge, Judge High Court of Bombay, and Honorable Chancellor's nominee in the Executive Council and the General Council of the University, Honorable Justice Mangesh Patil, Judge High Court of Bombay and Chancellor's nominee in the Executive Council and the General Council of the University, and my colleague, Professor Dr. Dhanaji Jadhav, Registrar, MNLU-A. It is also my privilege to welcome our esteemed guests of the dais, Honorable Judges, both sitting and retired judges of the High Court of Bombay Bench at Aurangabad. I must especially welcome Honorable Justice Vasanti Naik, Honorable Justice Ravindra Borde, Honorable Justice Sunil Deshmukh, Member of the Coordination Committee, Designated Councils, General Practitioner Advocate Amarjit Girse, and his team, President and Secretary of the Bar, our very dear Dr. Lakshminath sir, former in-charge Vice Chancellor of MNLU-A and Professor Emeritus, and my very dear students of the university. Maharashtra National Law University, Aurangabad was established under the Act 6 of 2014 by the State Legislature of Maharashtra and commenced its activities from March 2017. With the commencement of the university, it boosted the aspirations of the people of Marathwada region to be a home to an institution of excellence and importance as far as the nation is concerned. And this aspiration actually became a reality with the establishment of this university on a sprawling 53-acre campus. Maharashtra National Law University, Aurangabad is committed to impart high-quality legal education. A law school of excellence does not commit itself only to classroom teaching, but looks at teaching beyond the classrooms by experts and eminent resource persons who are role models to many. And today, we are honored to have with us none other than Hon'ble Shri Darius Kambata, Senior Advocate and former Advocate General of Maharashtra, who's an extremely eloquent orator, to address to us on the topic of basic structure doctrine, what it is and why it matters. His expertise and insights on the subject are unparalleled. Today, we are here not merely to commemorate a significant doctrine, but also to reflect on the profound impact it has on our constitutional jurisprudence, including the democratic ethos. When we think of the basic structure doctrine, we go back to the doctrine pronounced by the Supreme Court in the landmark judgment of Keshavananda Bharati, which to me is a testimony of resilience to our Constitution. It serves as a reminder that while the Constitution is a document which is a living document capable of evolving over time, its foundational principles must remain unshaken. The basic structure doctrine acts as the sentinel safeguarding the ideals of liberty, equality, justice, and fraternity, which are enshrined in the preamble of our Constitution, thus reminding ourselves that no transient majority has the power to dilute the essence of our Constitution. Today, this lecture is a valuable opportunity for all of us present here to dwell deeper into the topic through this address. As we come together for this academic endeavor, may this serve as a reaffirmation to our commitment to the rule of law and the principles that form the bedrock of our nation. And as the University Vice-Chancellor, I take pride that this university serves as a crucible for shaping young legal minds for tomorrow and acts as a forum for continuing legal education. I welcome all of you to this lecture with a firm belief that today's lecture will deepen our commitment to justice and equity. Thank you. Welcome, one and all.
Thank you very much, Madam, for your insightful address. Esteemed dignitaries, ladies and gentlemen, I deem it a great privilege and honor to speak a few words about Honorable Shri Justice Abhay Srinivas Ok. His Lordship's career spans over 4 decades. His Lordship had the rare opportunity of starting his career as an advocate in the chamber of his late father, Srinivas W. Ok, at the Thane District Court. In 1985-86, His Lordship joined the chambers of Mr. Tipnis, who was the former judge of the Bombay High Court. His Lordship appeared in several important matters and public interest litigations. On the 29th of August 2003, His Lordship was elevated as the additional judge, Bombay High Court. And on the 12th of November 2005, His Lordship was made a permanent judge. His Lordship became the Chief Justice of Karnataka High Court on the 10th of May 2019. And he took the oath as judge of the Supreme Court on the 31st of August 2021. So far as MNLU Aurangabad is concerned, His Lordship is the most respected and the most adored personality in the campus. Any serious problem we face, we look towards Delhi for His Lordship's valuable advice and suggestions. Ladies and gentlemen, without taking much of your precious time, I now invite His Lordship, Justice Abhay Srinivas Ok, to make the presidential address. Justice Srinivas Ok, please.
Good morning, dignitaries on the dais and dignitaries of the dais, and most importantly, young student friends. I welcome all of you to this second Justice M.L. Pendse Memorial Lecture. Justice Pendse was one of the best judges I have seen in my entire career. He was one of the most brilliant judges we had, and most importantly, he was a very quick judge. I had opportunity to appear before him as a young lawyer. He never wasted a single second of the court's time. He was completely different as a judge. There was one very important case which was argued before him. Future of a very eminent political leader depended upon the outcome of that case. There are many eminent lawyers from Bombay and outside Bombay. They were arguing that case. In those days, court time used to up to 4:45. The submissions ended at 4:42. Any other judge, either he would have reserved the judgment or he would have said that I'll start dictation of judgment tomorrow. At 4:42, he called his stenographer, secretary, and started dictation. I remember one eminent lawyer from Delhi was present. He asked his colleague what this judge is doing. He could not believe that Justice Pendse in such a serious case will start dictation of judgment when only time of 3 minutes was available. When I became judge on 29th of August 2003, I felt that Justice Pendse should be my role model. But after I worked for a few days, I found that it is impossible to reach the standards set by Justice Pendse. And that's why we are remembering Justice Pendse today. He was former Chief Justice of Karnataka High Court, and I was lucky to be Chief Justice of the same High Court. Many retired judges and many members of the bar had so many stories to tell me about Justice Pendse, how he worked, though he was there only for 8 months. Last year, we had lecture by Justice Ravindra Bhatt, my former esteemed colleague in the Supreme Court. This year, we are planning 2 lectures. The first was to be by Justice Ajit Shah, one of our greatest judges, a retired judge. And second was to be by Mr. Khambata. Due to health reasons, Justice Shah was not able to come here. We may hopefully call him on some other day. When I requested Mr. Khambata to come here, I had 2 subjects in mind. One was professional ethics. I have seen most of his career. I don't think there was any other suitable or eminent person to speak on professional ethics. But since this year we are going to celebrate 75 years of implementation of the Constitution of India, 26th of January 25, I thought that we should request Mr. Khambata to speak on a subject dealing with constitutional law. And the only subject possibly which we could think about and Mr. Khambata could think about was of Keshavananda Bharati. Remember, it's a 51-year-old judgment delivered in 1973. I'm not going to speak much on this judgment because we have such eminent speaker to address us. But to put it briefly, these are of course my personal view. Don't take it as views of sitting judge of the Supreme Court. This is one judgment which protected not only our Constitution, but ideals of our Constitution. This is one judgment which protected independence of the judiciary. This is one judgment which helped us to maintain democracy in India. This judgment has made all the difference so far as the democratic setup in India is concerned. Just look at what is happening on the left-hand side and right-hand side of India. Where is the constitutional machinery there? There is no constitution. There is no independent judiciary. This great judgment written by those great judges has protected our fundamental rights. And as I said, it has protected ideals under our constitution. It is always fascinating to read this judgment. You get a different outlook, different idea when you read this judgment. I'm sure Mr. Khambata will speak about it. I remember I addressed students of a law school on the subject of the 75 years of Constitution. One of the students got up in the interactive session. He asked me a question. Sir, why we needed a judgment like judgment in the case of Keshavananda Bharati, holding that the power to amend the Constitution cannot be exercised to affect the basic structure. Why we needed this judgment in independent India? Only after you read the judgment, you realize that why we needed that judgment, and most importantly, you must study the history of India, history of democracy of India, history of political institutions in India during last 50 years or 51 years. The young students will realize the importance of Keshavananda Bharati. Academically, sometimes I feel that if that summary would not have been there in the judgment, perhaps it would have become very difficult to interpret that judgment. And that judgment is here for last 51 years, 51 long years. Whenever judges from abroad come to Supreme Court, we had occasion to meet them. Perhaps the first question they ask us is about Keshavananda Bharati judgment. And they are so fascinated by the concept evolved by the Keshavananda Bharati judgment. So I won't take much time because Mr. Khambata is most eminently suited speaker to speak on basic structure theory. Mr. Khambata appears before me and is going to appear for a few more months before me. Therefore, I won't say much about him. But I'll say only two things in brief. I have been a judge of the Bombay High Court. I started practicing in Bombay High Court in 1985. I was a judge in Bombay High Court for 15 years and 8 months. On my experience, I can say that he was the best advocate general which Maharashtra had seen, at least I have seen. It may be my individual opinion. In fact, I remember telling Mr. Khambata in one of the functions when he decided to demit the office, that I said, I'll sit in the court and issue a suo motu writ of mandamus to continue as Advocate General. And I must quote the answer which he gave. He said, I'll prefer to face contempt proceedings. And therefore, we have such an eminent speaker here. I won't take more of your time. Only one request I want to make to young students. I think we have 10 minutes for interactive session. So please ask questions dealing with Constitution, dealing with Keshavananda Bharati, because we will not get opportunity to have such eminent speaker. So please take advantage of those 10 minutes. If necessary, we can expand it to 20 minutes also. So thanks for attending in such large numbers. Thank you.
Thank you very much, Your Lordship, for sharing with us your rich experiences with late Honorable Shri Justice M.L. Pendse, and also for your inspiring and motivational message. Thank you so much once again. Ladies and gentlemen, I now request our final year student, Ms. Arya Asolkar, to kindly introduce the chief guest, Shri Darius Khambata, to the audience. Ms. Asolkar, please.
A very good morning to one and all present here. It is indeed an honor to introduce our speaker for today. Mr. Darius Khambata, Senior Counsel, practices in the Supreme Court, Bombay High Court, other high courts and tribunals across India. Sir has held distinguished public law offices as Advocate General of Maharashtra and before that as Additional Solicitor General of India. Mr. Khambata schooled at the Cathedral and John Cannon School and graduated from Sydenham College, Bombay. Sir obtained his LLB from the Government Law College, Mumbai, before being conferred an LLM from Harvard Law School. In the year 2014, Sir was awarded the Arya Chanakya Puraskar in Law and was awarded Living Legend of Law by the Bar Association of India in the year 2019. Sir joined the bar as a junior to Mr. Iqbal Chagla, and during his early years, he was actively involved in several major corporate litigations, including the Indian Express Group, Britannia Group, and in several matters before the Special Court dealing with the 1992 securities scam. Mr. Khambata has a large, varied practice and has appeared in numerous significant constitutional, corporate, and commercial matters, as well as domestic and international commercial arbitrations. Sir was part of the Law Commission of India's committee, which framed and recommended substantial amendments to the Arbitration and Conciliation Act of 1996. He was Vice President of the London Court of International Arbitration and is a member of the Singapore International Arbitration Court Centre. Sir is also a member of One Essex Court, a leading set of commercial chambers in the United Kingdom, apart from having his own chambers in Mumbai. Carrying the legacy of legal stalwarts ahead, Sir holds the position of trustee at the M.C. Chagla Memorial Trust and the H.M. Sirvai Memorial Trust. His work relating to environmental issues and pro bono litigation is truly an inspiration for students like us. We are grateful to have you here, sir. Thank you so much.
Thank you, and God bless you, Arya. Ladies and gentlemen, the moment for which you have been waiting for so long has come. With great respect and honor, I invite the chief guest of today's function, Sri Darius Khambata, to deliver a lecture on the basic structure doctrine, what it is and why it matters. Mr. Darius Khambata, please.
Honorable Justice Oak, Honorable Justice Kuge, Honorable Justice Mangesh Patil, Vice Chancellor Professor Ronald, Professor Lakshminath, Justice Vasanti Nayak, sitting and retired judges, and my dear friends and students. It is really a privilege and honor to deliver the Justice M.L. Pendse Memorial Lecture. I refuse to call him the late Justice Pendse because in my mind and in the minds and hearts of so many of us, he will always remain alive. He was one of the greatest judges that I have ever appeared before. Fiercely independent, solid grasp of legal principles and doctrines, sound common sense and a desire to do justice, and extraordinary speed with which he combined all of this. He always got to the pulse of the matter in a matter of minutes. As juniors, we were all petrified to appear before him. But when we actually did, we found him actually to be a very good judge to appear before because he never treated juniors and seniors differently. I remember a matter where I had a pretty hopeless case in retrospect. He heard me for over an hour and gently sort of dealt with all my points, gave a judgment obviously dismissing my petition, but he added one last para which 15 years later stood the client in remarkably good stead. So he had that vision as well. His smile disarmed you. It was said that when he smiled at you in court, alarm bells should be ringing because the axe was going to fall on you. And he always encouraged parties to settle. And if you didn't settle, then of course also the axe fell upon you. He later became a formidable arbitrator, and I appeared a lot before him. Justice Tipnis used to sit with him quite regularly, Justice Chandurkar. And he was a phenomenal arbitrator as well. Look, long before 29A of our Arbitration Act, I'm talking about the early part of this century, I appeared in a matter where I remember a reference order was given by the High Court in December of some year. He gave directions immediately. Pleadings were complete by February, affidavits of evidence by March, full evidentiary hearing in late March or early April, 2 weeks gap, towards the end of April, arguments, written submissions, and by the first week of June, we had a full detailed speaking award on a very complex topic. It was on these take or pay clauses, I remember. But that was the capacity of the man. As I said, he was fiercely independent. And one of the things that will always stand to his credit is he resigned as the Chief Justice of Karnataka a day or two after a judge who was junior to him was appointed to the Supreme Court. He therefore joined the great company of superseded judges. And that's what I'm here to talk to you about today. 24th April 1973 is one of the most important dates in our history. Because on that day, the judgment in Kesavananda Bharati was delivered by 13 judges of the Supreme Court, and India was pulled back from the precipice of disaster into a secure constitutional democracy. The very next day, 25th April, was one of our darkest days because the 3 senior-most judges of the Supreme Court were superseded and Justice A.N. Ray was appointed above them as Chief Justice. And remember one thing, we all know even today that usually a month before the Chief Justice is to retire, the name of his successor is announced. But the government of the day held back that announcement because they wanted to see what the judgment in Kesavananda was going to be. And only the next day after that, the very last day on which Chief Justice Sikri sat, did they announce his successor. Justice Ray was part of the minority 6 judges in Kesavananda, and Justices Shelat, Grover, and Hegde were part of the majority of 7. So the empire struck back very swiftly and very brutally. And it was the price that they paid for saving democracy in India and for doing their constitutional duty. How did all this come to pass? You must remember, and we tend to forget nowadays, what the problems before our country were in 1947. What sort of a nation we inherited. First of all, it was not one united nation. There were hundreds of regions, princely states, etc., divided by not only by religion, by language, by community, by caste. We were an exceptionally poor nation because we had suffered the ravages of colonialism for at least 200 years. So at the top of the agenda of our founding fathers were reforms, social and agrarian reforms. And one of the means of introducing these agrarian reforms was to introduce land ceiling laws and land reform laws. Now, High Court started striking these down as being expropriatory of private property, etc. In 1951 came the First Amendment. And as far as we are concerned today, it introduced Article 31B, which immunized a law from a fundamental rights challenge. Because as you know, Article 13.2 says any law which abridges or abrogates any fundamental right shall be void. It immunized that if that act was introduced in the 9th schedule. As Professor Gajendra Gadkar had said, it is a unique provision which protects constitutional provisions from themselves. So it's only in our country that we have this. Now, the First Amendment was challenged in Sankari Prasad, and there, of course, the Supreme Court held amending powers were absolute and plenary, and Article 13.2 applied to ordinary laws. It did not apply to any act of parliament in its constituent power to amend the constitution. So this raised a paradox, come to think of it. Any ordinary law which infringed even one fundamental right would be struck down as void. But a constitutional amendment which abrogated the entirety of Part 3, abrogated all fundamental rights, would be constitutionally valid. Sajjan Singh, 15 years later, reaffirmed, but by a smaller majority, 3-2. And the minority in that case, Justice Mudholkar, was very prescient. He asked a question: can a change in a basic feature of the Constitution be regarded as merely an amendment, Or would it in effect be a rewriting of the Constitution, and therefore would it be within the purview of the amending power under Article 368? And he looked across the border to Pakistan, where just 2 years before, in 1963, Chief Justice Cornelius had delivered a decision which said that franchise, adult franchise, the right to vote, and form of government were fundamental features and could not be amended by the amending power then conferred on the President of Pakistan. These are the first stirrings of the basic or essential features doctrine. And I believe one can't understand that doctrine unless one first understands what a constitution is. What is a constitution? Is it some ordinary piece of law? Or is it something more than that? Is it a statement of ideals? Is it a path that a nation chooses upon which it promises future generations it will trod and beyond the parameters of which it will not stray? The Constitution itself sets the boundaries beyond which other laws cannot be made, and upon which they draw their validity. But I think it's more than that. It's also a dream, an aspiration, and a hope that brings a country together, that unites a nation. It is a far stronger unifying factor than any tangible factor, such as religion or caste or language or region. It unites a country by an ethos and by a goal. And the question is whether those ideals, that ethos, or those goals are permanent or alterable. Interestingly, the first time one notices the stirrings of a basic structure doctrine in constitutional law comes from Oliver Cromwell, Lord Protector of England, who had read the English Revolution, deposing Charles I. He had introduced in Parliament something called the Instrument of Government. This was in 1653. And he said that this instrument must be something that must last. It must be an inviolable rule against the shifting majority decisions of Parliament. He actually used those words. Something so fundamental or absolutely unbreakable. Of course, despite that, that instrument itself was revoked by Parliament after 4 years. It didn't have much of a life. That is one model. The other model was the French model. After the French Revolution, the French have had no less than 14 constitutions, the last of which being in 1958. And the 1793, the second constitution they had, actually had Article 28, which allowed Parliament or their version of the legislature to amend or alter or even change the constitution. Fast forward to the year 1919, when an American jurist called William Marbury first envisaged that a constitution may have an express amending power, but that did not exclude an implied limitation on that power, which was not expressed in the Constitution. So Article 5 of the American Constitution had certain limitations for amendment, but it was quite plenary. And one of the limitations was that the American states would not be denied the equal suffrage in the Senate. As you know, even today, every American state has 2 senators each in the Senate, regardless of whether it's a large state or a small state. This was the insurance given to small states to entice them to join the Union. American courts, even then, in the 1890s, had given decisions by which they had said that even though there was no express limitation on Congress's taxing power, Congress, that is the federal Congress, could not make any statute that took away the legislative powers of the states, including their power to tax, because they felt that taking away these powers would cripple states and would render their very existence in peril and thereby destroy them. Therefore, even though there was no express limitation, US courts had said US Congress cannot do this. And Marbury argued that a similar doctrine could be extended to anything that would change the framework of the federal government, or the distribution of powers between departments, or abolish guarantees of civil liberty. But he left the question unanswered. And in fact, the US never answered it. And indeed, the US Supreme Court has categorically rejected such a theory of implied limitation of amending power. In 1928 comes a very seminal work. If you recall, after the First World War, the Western powers imposed a democracy on Germany. And the Weimar Republic came into being, and there was a Weimar constitution. Why Weimar? Because that was the small town where it was promulgated. Now, Schmidt said in 1928 that changing constitutional laws was not a normal state function. It was an extraordinary authority. So he made that difference between legislative powers and constituent powers. And he then said that the power to change or amend constitutional laws was not the same as the power to get a new constitution. And therefore, the amending power could be exercised only so far as it would preserve the existing constitution. He said constitutional amendment is not the same as constitutional annihilation. And he was therefore critical of the majority decides principle and warned of its unfairness. He preferred a qualified alterability or amendability, which contained some guarantee of duration and protected a constitution from shifting parliamentary majorities and yet allowed it to grow and develop and change in the future. Now, of course, ironically, this is an aside, Schmidt himself later became a willing instrument of constitutional dictatorship when he collaborated with the Nazis between 1933 and 1936. But nevertheless, his 1928 work remained. It's interesting to see what can happen if you don't have a basic structure doctrine. This is, of course, a very extreme example, and one would never contemplate it happening anywhere. But it did happen at least once. And it's worth, therefore, seeing what happened in Germany. The Nazis, as is well known, never got more than about 43% of the popular vote in Germany in no election. And there were some repeated elections in the early 1930s. They came into power more or less in a coalition in 1933. And almost immediately, the parliament building Reichstag was set on fire. Now it is found they had themselves engineered it, though they caught some Dutchman who was a communist and said he's responsible and put him on trial. And swiftly thereafter, they made that parliament with their allies pass what was called the Enabling Act in March 1933, which enabled the executive government to rule by decree and totally bypassing parliament. And those decrees could even go in deviation of the constitution. Now, using this plenary power, and they passed it by the requisite two-thirds majority amendment in the parliament. Using this power, in July 1933, 3 months later, they passed a decree declaring that the Nazi party was the only legally recognized party, and immediately called elections a few months later. So by November 33, you had a new parliament, 100% composed of only the Nazi party. Now, the new parliament then passed a law in 1934 called the Reconstruction Act. And the Reconstruction Act, which was passed, of course, unanimously, said the government now has the right to enact even new constitutional law. So this was a way of using constitutional provisions to effectively destroy the constitution by amendment. This is why, post-war, the German constitution contained, which is called the Basic Law, contained an express clause called the Eternity Clause, which prohibited amendment to certain fundamental parts of its constitution, which were federalism, rule of laws, democracy, separation of powers, etc. Now, our Constituent Assembly apparently did not actually lay too much emphasis on the German constitution. It studied a variety of other constitutions. But these events caused a group of professors at Heidelberg University, led by Professor Dietrich Konrad, to make a study of these principles. And this is why law schools such as yours are so important to even the future of a country such as ours. Konrad came and delivered a now very famous lecture in 1965 at the Banaras Hindu University. He first started by noticing the propensity of the Indian Parliament to amend the Constitution. He said, look at the US. They have had 22 amendments in the last 175 years. This was in 1965. India has already had 17 amendments in 15 years. And of course, today we are on the 106th amendment. He said, and he worried about this exercise of amending power. He said, when a party commands a two-thirds majority in Parliament, use of this power indiscriminately puts not Parliament, but this party into the position of a sovereign above the Constitution. I'm quoting him. it is in fact not less dangerous for constitutional limitations than a protracted emergency. He therefore argued that notwithstanding the express limitations in Article 368, they would not guard against such frequent amendments for political purposes. And of course, he cited the German example. He posed three questions, which, extreme as they are, make us think. The first question was, could a constitutional amendment abolish Article 21 to the effect that forthwith a person could be deprived of his life or personal liberty without authority of law? Second, could the ruling party, if it sees its majority shrinking, amend Article 368 to the effect that the amending power rests with the President acting on the advice of the Prime Minister? And third, could the amending power be used to abolish the Constitution and reintroduce, let us say, the rule of the Mughal Emperor or of the Crown of England? Now, these are extreme examples, but he used them to demonstrate that there are limits to the amending power, which limits may not actually be stated in Article 368. He said 368 gives you a formality or a procedure for amendment, but that power has to be exercised within the framework of a certain basic concept of what the essence of the Constitution should be, or the concept of a basic constitutional structure behind the text of the constitutional document. And he therefore opined that such basic structure could not be changed by constitutional amendment, because that basic structure was adopted by the people of India in their constituent, and he called it revolutionary power, and the amending power could not be used to usurp this. The essence of his doctrine, which he defined, is very interesting. He said, you cannot take out certain basic elements out of such an organic system without destroying the whole. Consider a simple example. The human body. If someone, because of some drastic ailment on us, requires an amputation of a limb, it's still the same person after that. Or requires very extensive treatment, he's still the same person after that. But if you say, remove his vital organs or remove his heart, can the body ever survive? And that was his thesis, that if you remove what is essential or vital, then you don't have left the Constitution. Now, of course, under Article 144(3), the Supreme Court is the sole arbiter and exclusive jurisdiction to interpret the Constitution. Therefore, it falls to the Supreme Court to decide what that essential or basic feature is. From 1951 to Sajjan Singh's case in 1955, the Supreme Court said no, power to amend was plenary and limitless. Then came Golaknath's case. Now, I don't have time to go into the facts of Golaknath, which are quite interesting actually. But in Golaknath, for the first time, that great jurist, Mr. M.K. Nambiar, father of Mr. K.K. Venugopalan, former Attorney General, he cited the Conrad speech to the Supreme Court, and he said, therefore, your powers of amendment are implied. They are impliedly limited. Supreme Court chose a totally different route. It said Article 368 contains the procedure for amendment, but not the power. The power comes from Article 245 and entry 97 of List 1, the residuary power. It then said Article 13(2) would cover even constitutional amendments, since the process of amendment was ultimately through the legislature. But it said that fundamental rights under Part 3 were transcendental, sacrosanct, inviolable, primordial, and therefore could not be abridged or taken away. Of course, the judgment was adopted the prospective overruling principle, and therefore neither Golaknath or his family or the Bhatte family, because the Mysore Land Reform Act was also got the benefit of that. But again, there the minority dissenting, Justice Bachawat, raised a word of caution. He said, if you adopt this theory, you will get a static system of laws. And that will mean, even if you can accomplish a unique feat of assembling the then entire population of India of 500 million people in a particular special convocation, even they could not amend Part 3. And that this would lead to a deadlock, and ultimately the only way out of the deadlock was unimaginably but a revolution. Now, Of course, if I had more time, I would explain to you, after this came the bank nationalization case, the Privy Council case, and the government felt threatened that its powers of legislation and constitutional amendment were being slowly eaten away. So first comes the 24th Amendment, adding 13(4), saying nothing in this article shall apply to any amendment of this constitution made under Article 368. So straight away, you took care of what Golaknath had said, that it would apply. Then 368(1), notwithstanding anything in this constitution, Parliament may, in exercise of its constituent power, amend by way of addition, variation, or repeal any provision of this constitution in accordance with procedure laid down. So this really expressly strengthened the amending power. It then came the 25th Amendment. Article 31C was added. 31C said, notwithstanding Article 13, which nullified any law in abridgment of fundamental rights, if a law was enacted to give effect to directive principles, then it could not be declared as void under Articles 14, 19, or 31. And that a parliamentary declaration to the effect that it was to secure those directive principles was itself not judicially reviewable. 26th Amendment changed the entire substratum of the Privy Purses case, and the 29th Amendment put the Kerala Land Reforms Amendments Acts into the 9th schedule. So this was like a tsunami of an assault on the Constitution. And it was the answer to Golaknath. So comes the judgment in Kesavananda. His Holiness Sri Kesavananda Bharati was the head of a mutt in Kasargod in Kerala. And he and several others filed petitions challenging the Land Reforms Amendments Act, etc. Now, this is very interesting. At the very beginning of the case, Chief Justice Sikri made it clear that the bench was keen and inclined to overrule Golaknath. He said all fundamental rights are not sacrosanct. The matter went on for 66 days. And there's a very interesting story which I can divert to tell you all. On the very first day, the petitioner side was represented by 3 leading counsel, Nani Palkhiwala, Chief Justice Chagla, who had retired by then and was practicing in the Supreme Court, and the great, the legendary C.K. Daftari. Both of them, Chagla and Daftari, said, let Palkhiwala argue it. We will sit and we will address, if necessary, after him. On the first day, the 13 judges who were very enthused about the topic were firing questions at Palkhiwala, one after the other. He couldn't really develop any argument. And at the end of the day, he's very flustered. He used to perspire a lot in court, and he was getting very flustered. He said, I can't go on like this. So C.K. Daftari, Chandubai, as he was then known, said, don't worry, I'll take care of this. Chandubai, puffing on his pipe, went to meet Chief Justice Sikri in his chambers. So Chief Justice said, oh, Chandubai, how nice of you to come, etc., etc. So Chandubai said, no, I want to share a story with you. There was this young student who came to view the proceedings today. And she was so impressed with this court, so impressed with your lordships. She said, these 13 wise men, what erudition, what wisdom, what fantastic knowledge I've gained. But who was that impertinent man interrupting them all the time in a black gown at the bottom? So Chief Justice Sikri said, Chandubai, I get your point. I understand. Next day, of course, Chief Justice Sikri ensured that the arguments proceeded. There are many other interesting stories, including how Mr. Popper drove a taxi to get a book into court, but I don't want to detract at this point into all that. Now, what Kesavananda therefore held, because again, Conrad's article was cited and a lot of other legal research and law was cited. First, and there are shifting majorities within the judgment. So as Justice Oak said, it was quite helpful that 9 of the judges later signed what they felt was the summary, but that itself is quite controversial because later Supreme Court judgments have not accepted that. But broadly speaking, I think one can say they first all 9-4 the overall Golaknath. And they went on the basis then of a very significant concession. And this shows the fairness of the two counsel made by H.M. Sirvai, who was appearing for the state of Kerala, and Mr. Nirande, the then Attorney General. Both of them accepted before the court that the amending power could not be used to abrogate or repeal the Constitution and to substitute a new one in its place. So that was the entire basis of the argument. Now, this inevitably had significant consequences because, as I told you, if you can't replace or kill the body, can you take out a vital organ or its heart? Because that was then the obvious question that followed from this concession. So, of course, all of the judges held you cannot use the amending power to destroy or abrogate the Constitution or substitute a new one. And then they held that Article 368 does not enable Parliament to alter or destroy the basic structure or framework of the Constitution or to completely change its fundamental features so as to destroy its identity. One has tried to cull out from the various judgments this finding, and you find it in the judgments of 7 of the judges at least. Now, Justice H.R. Khanna, the uncle of the present Chief Justice of India, was the pivot on which the entire judgment turned. He was a great judge. That's another story, why he was so great, but he was a very erudite judge. He said, he is the only one, I think, in the judges who actually noticed Conrad's judgment in his judgment, the speech in his judgment. He said, I don't agree with all of it, but I agree with certain basic parts of it. He said, I don't think you could read a broad implied limitation into the amending power. But he said, you could read in a limitation in Article 368, either expressly, the words used, and there are certain provisions which require special majorities, some which require states to ratify, etc., and some which arise by necessary implication. And he said the necessary implication arises from the very use of the term amendment of this Constitution. And he said amendment of the Constitution, the words carrying with them, and I quote, with all their wide sweep and amplitude, cannot have the effect of destroying or abrogating the basic structure or framework of the Constitution. And he said, he gave an example that a democratic government cannot, by amendment, be changed into a dictatorship or monarchy, or parliament cannot be abolished. And of course, other judges also held that the express limitations on the amending power in 368 were themselves basic features of the Constitution. However, Justice Khanna held that this did not mean all fundamental rights were part of the basic structure. And he said Article 19(1)(f), the right to property, is not part of the basic structure. And that he then joined the minority 6 judges and made a new majority of 7 to hold 19(1)(f) was not part of the basic structure. So you had the basic structure implied amendments. You cannot change essential features. But 19(1)(f) was not held to be an essential feature. And therefore, the land reform laws were held to be valid. The 25th Amendment was actually validated, but the latter portion of Article 31C, which excluded judicial review and made the declaration of Parliament unquestionable, was struck down. And judicial review, amongst other things, was held to be unalterable as part of the basic structure. So the majority artfully balanced the need for some permanence in the Constitution of essential features against the need for a flexible Constitution that supported reform. It was a remarkable exercise when you come to see it. Now, as I told you, the day after this, there was the supersession of the 3 judges. But during the emergency, a very interesting thing, Chief Justice Ray suddenly, suo moto, without any application, convened a second 13 judges bench. Many of the judges were common, to review Kesavananda. Now, unfortunately, this is not a reported decision or order at all, because it went on for 3 days. After the first 2 days, I think the Chief Justice sensed that his brother judges were not with him, or not the majority at least. And the 3rd day, he suddenly came to court, and unbeknownst to his brother judges, he just announced at the opening of the day, bench dissolved, and they all rose. This is noticed only by a few people who were there, and Justice H.R. Khanna has written afterwards that Palkhiwala's advocacy in that review petition has been of a level seldom heard and never surpassed before the Supreme Court. Because Nani flew up to defend the Kesavananda judgment. And of course, thereafter, after the emergency, was the Minerva Mills judgment. Because by the 39th Amendment, judicial review was taken over out of the purview of elections of the President, Vice President, Prime Minister, Speaker, etc. That was struck down. 31C, which had been added by the 42nd Amendment. It's worth reading the 42nd Amendment. It's huge. It's like a mini constitution in itself during the emergency. All sorts of things were added. It said laws prohibiting anti-national activities are not subject to challenge under 1419-31, things like that. But 31C had said that any law giving effect to a directive principle would be immunized from 1419 and 21 rather, and Parliament's declaration again would not be judicially reviewable. All that was struck down in Minerva Mills. And there, the Supreme Court noticed the balance, that the Constitution is founded on the bedrock of a balance between fundamental rights and directive principles. Any attempt to give primacy to directive principles would disturb that harmony. And goals in Part 4 were to be achieved without abrogation of the fundamental rights in Part 3. Otherwise, it said, if articles such as Article 31C were not struck down, fundamental freedoms would become, and I quote, a parchment in a glass case, just for show, but not in reality operating. Now, the basic structure doctrine, however, I took a huge leap forward also in the I.R. Coelho case in 2007 and reported in 2009. If you remember 31B, which came in the First Amendment in 1951, had said if Parliament puts any statute in the 9th schedule, it will not be subject to judicial review on 1419-21. That had remained to be set aside in Kesavananda. Kesavananda didn't touch upon that or actually strike it down. So that came up before 9 judges of the Supreme Court in Coelho's case. In Coelho's case, they slightly attenuated the theory by saying that although you could put legislation in the 9th schedule, if that legislation altered the basic structure of any essential feature of the Constitution, and on that anvil it would have to be tested, then it could be struck down, notwithstanding it was in the 9th schedule. So in a sense, 1419-21, which were also then held to be part of the basic structure or essential features, revived. And notwithstanding the 9th schedule, they are still to be seen to test even acts put in the 9th schedule. Therefore, effectively 31B was struck down, at least as far as the important fundamental rights of 14, 19, and 21, which is pretty much the menu on which we lawyers challenge litigation or legislation today. Now, textual support, of course, there always is for basic structure in Article 368 itself, because it says you can use the power of addition, variation, or repeal of any provision of this Constitution, which would mean that after that power is exercised, it must still remain this Constitution, not some other Constitution. And it also uses the term, the Constitution shall stand amended. That means it's still standing after the amendment. It's automatically amended. It's the same Constitution, it has to be. It's obviously not the same Constitution in every letter, because you've amended part of it, but therefore it's the same Constitution in its essential character or features. And Justice Khanna actually referred to this in his judgment. Now, over and above this, of course, is the theory of implied limitations, which are not expressed. But Justice Khanna preferred to use the language of 368 to draw the same conclusion. There are some criticisms of the basic structure theory, and we must address those. The primary criticism is that it permits unelected judges to invalidate a structural change made by an elected parliament, even if it is unanimously approved of by parliament. That's one criticism. But of course, it's worth remembering, when you consider this, that the Constituent Assembly itself was indirectly elected. It was not a directly elected body. Second is, if you read the Constituent Assembly debates, it seems that the sense of the members at that time was that apart from fundamental rights, no other part of the Constitution was considered as unalterable. And indeed, the final draft of the amending power reflected that wish of the members. In fact, many members wanted amendment by simple majority. Jawaharlal Nehru felt that whereas it's good to have a solid and permanent constitution, it must be a flexible constitution that permits national growth. And he said this first when Dr. Ambedkar introduced the draft clause. Later, a few months later, when it was actually debated, Nehru did not intervene in the debates, nor did he move his amendment. So his amendment never got moved, but it's very clear from the debates that most of the members wanted easy amendability. Some even said, all right, for 5 years, have easy amendability of the Constitution by a simple majority. And thereafter introduce the special majorities proposed by Dr. Ambedkar. As you know, there are three special majorities, including the last certain provisions have to be ratified by states. Dr. Ambedkar stood alone, at least in those debates, warning against easy amendability. And he said this. He said, in fact, the purpose of a constitution is not merely to create the organs of the state, but to limit their authority. Because if no limitation was imposed upon the authority of the organs, there will be complete tyranny and complete oppression. The legislature may be free to frame any laws. The executive may be free to take any decision. And the Supreme Court may be free to give any interpretation of the law. It would result in utter chaos. I have not been able to understand when it is said that the Constitution must be made open to amendment by a bare majority. And ultimately, the great jurist and nationalist that he was, Dr. Ambedkar's view prevailed over the view of most of the members. And on an aside, if one reads those debates, one is struck by the civility, the politeness, the erudition with which members interceded and spoke. They cited authorities, they quoted, they were extremely polite to each other. And secondly, the force of Dr. Ambedkar's personality comes through in those debates. It's worth reading selectively some of these debates. And therefore, they took the view that a constitution is not to be entombed. You must have amendment as a safety valve to mold the path in the future. It is not immutable, it is a living thing. But why does, according to me at least, the basic structure theory matter? The first is, I think the most obvious. What is a constitution? It is a document that protects the individual and the rights of the individual from the majority. Elections to parliament are only one facet of democracy. They don't make a democracy. Fundamental rights, civil liberties, separation of powers, independence of the judiciary, power of judicial review are all key components of democracy, and you therefore need a constitution to protect them. If the constitution itself was made susceptible to change by the view of the then prevailing majority, then the raison d'etre for a constitution itself vanishes. So once you have a constitution, inbuilt in that is that certain basic features can't be amended. And parliament, of course, secondly, represents only the electoral mandate of that moment. It's a transitory majority. We've seen that majorities come and go. Can the occupant of a house, who is transient, he can make alterations within the house, but can he alter the house by destroying it and rebuilding its foundations? The answer in constitutional law is no. There's a lot of study done also what is meant by majority. Because in our Westminster system, it's first past the post. Often, popular vote says 52% in favor, 48% against. But 52% can get a sweeping majority in parliament. So some authors have contended that really it's only that 4% that has made the difference. Is that really such a commanding majority? And there are many such arguments. And Schmidt himself said in his article, way back in 1928, that the authority to undertake constitutional amendments resides in the framework of the Constitution and is established through it and does not extend beyond it. And of course, necessarily, the only authority that can decide whether an amendment is constitutional or not is the Supreme Court, because you can't have Parliament itself sit in judgment over its own act, or the executive, which is really the majority in Parliament who forms the executive. And we have also seen, and this is worth noting, that since independence, the basics, or since 1973 at least, the basic structure theory has not hampered any economic development or social reform or technological revolution in our country. In fact, India has in the last 20 or 30 years has had spectacular success. I wish some of the students were there in 1991. We all remember it, in what a crisis our nation was. and where we have come from that day. And the basic structure theory has not affected that. So the myth that you've got to get rid of all these shackles, you can't have proper development, is only a myth. It's nothing more than that. The real challenge on the basic structure theory is, how do you define or identify which are the essential features of the Constitution? As you know, the Supreme Court has been evolving tests. In Nagraj, they had a twin test of width of the test, obliteration of any constitutional limitations, and the test of identity, which are the essential features that give it identity. In Coelho, they said the actual impact, the consequence is very important. But the question is, how do you decide what is basic? Now, in Indira Gandhi Nehru case in 1975 during the emergency, the Supreme Court, which even during the emergency upheld the power of judicial review and struck down parts of that amendment, said you have to see the place in the Constitution of that particular feature, what is its object and purpose, and what are the consequences of a denial of that. And from time to time, different benches of the Supreme Court have had different tests and have come to different conclusions. I am proposing that perhaps the historical background to how our Constitution came into being could also be taken into account to decide what are the basic or essential features of the Constitution. How did our Constitution come into being? To my mind, it's the culmination of a freedom struggle which lasted for at least 100 years before that. Now, the call for complete independence, or Purna Swaraj, as you all know, came in the 1929 Lahore resolution of the Congress. That's a good starting point. What did that resolution say? It noticed the fact that India had been ravaged by colonialism, was being completely exploited. It recognized the inalienable right of Indians to have freedom, particularly freedom of expression of opinion and free association, because more than 7 people could not even associate, and to enjoy the fruits of their toil and have the necessities of life. These are simple words, but they encapsulate great ideas. And the idea in Purna Swaraj was to regain economic control of our own country so that Indians will have full opportunities of growth. It was to reverse the ruination of India, which up to then was ruined economically, politically, culturally, and it was felt even spiritually by colonialism. The next station on this path is the Guiding Principles Resolution in 1946, which was moved to start the debates in the Constitution. That looks very much more familiar, because that refers to the fact that all the power and authority of the state and sovereign India is derived from the people. Justice, social, economic, political, equality of status and opportunity, freedom of thought, expression, belief, faith, worship, vocation, association, actions is guaranteed. Safeguards provided for minorities, backward and tribal areas, and depressed and other backward classes, and the integrity of the territory of India and its sovereign rights. And it ended by saying this ancient land attains its rightful and honored place in the world and makes its full and willing contribution to the promotion of world peace and the welfare of mankind. Now, this is not just some stray salutary exhortation. I don't know how many of you have read a wonderful book that has just come out called The Golden Road. Please read it, because it tells us how for a period of over 1,000 years, by soft power, Indian religion, culture, mathematics transformed not only the whole of Asia, including China, but the whole world. It's very well documented and researched. It's worth reading. And that's the rightful place that our founding fathers wanted us to regain. So, broadly speaking, in the short time that I have, let me try and summarize what do we get from this historical context. What are the essential features? First would be freedom and liberty from the individual, from the state. Whoever your ruler is, you must have civil liberties, free speech, right to form associations, etc. Of course, it's ironical that even today, the colonial law of sedition still remains on our statute books. Second is the rule of law. What is the rule of law? It means you will be ruled by a set of laws, not by men. And in our national flag, at the very heart and center of it, is Ashoka the Great's Dharma Chakra, the wheel of law, 24-spoked wheel of law. The freedom struggle was all about this, against the tyranny of the colonial ruler. And it sought to dismantle this. How did it seek to do it? 3 ways. One is by instituting a constitutional democracy. free and fair periodic elections, judicial review, independence of the judiciary, and of all institutions of democracy from the ruler. Secondly, the dispersion of the singularity of colonial power. The king, emperor, viceroy, and millions of Indians then were ruled by that, by the doctrine of separation of powers and by federalism. And thirdly, self-determination or self-rule. So these form part of the liberty and freedoms compact, which I believe is part of our essential features. Third, of course, very important, is equality. Economic, social, and political justice for all. Elimination of all forms of discrimination, including by caste and gender. Development of scheduled castes and tribes, backward classes, and agrarian and social reform to bring in true equality for everyone. After all, remember what Gandhiji has said, that the ultimate mission was to wipe every tear off the eye of every Indian. That remained our mission in our constitution. And lastly, fraternity. Our founding fathers were acutely aware of the rich diversity of India. Diversity of language, culture, religion, geography. But that diversity could lead to fractures. So they were very anxious to have a cohesive, united India, which really had only been achieved under Ashoka the Great and thereafter under certain rulers, including the Mughals. But that was by force. You were to unite this India. You were fresh from the horrors of partition. You were fresh from the creation of a religious state, or state founded on the basis of religion rather, Pakistan. Our constitution is our constitutional answer to all of that. And therefore there are protections for individuals, for minorities, and for the right of freedom. These are the 4 basic compartments. Of course, it's not an exhaustive list. But I think it's important to remember that basic structure can't be a long laundry list. It's better to identify basic goals and objectives rather than analyze the means the Constitution chooses to attain those goals. That distinction has to be kept in mind. And this can work even for what are known as constitutional silences. For example, unenumerated liberties, the right to privacy, which recently the Supreme Court upheld. It's part of Article 21. Doctrine of non-arbitrariness, from Royappa's case onwards, part of Article 14. So it's not difficult to incorporate even more recently identified liberties and rights within this historical framework. As far as other countries are concerned, Justice Oak has told you, after that initial burst in 1963, Pakistan actually set its face against the basic structure theory. There are several decisions. And we all know what the result is. Now, no one has actually done an analysis of whether the theory supports or helps democracies. But I dare say if such an empirical theory is done, you will find that this usually conserves and saves democracies. Recently in Israel, for example, when Parliament sought to amend the power in their constitution given to their Supreme Court to strike down government action on the ground of unreasonableness, sought to take that away, the Supreme Court said, no, this reasonableness is part of our basic characteristics of our constitution. The amendment has to be struck down. So I end with this. Remember what you say, hear, read, write, eat, all depends on the Constitution and how it is interpreted. Every facet of our human life. But the Constitution is fragile. It's wise to keep in mind the words of that leading American jurist Joseph Story, who said, the Constitution has been reared for immortality, if the work of man may justly aspire to such a title. It may nevertheless perish in an hour by the folly or corruption or negligence of its only keepers, the people. Implying limitations on Parliament's amending power is one of our insurances against destruction of our Constitution. So I leave you with those words of Nani Palkhiwala during his argument in the Minerva Mills case, where he put it very pithily. He said, if Parliament had the power to destroy the Constitution and its basic structure, it would cease to be a creature of the Constitution and become its master. That's the essence of the basic structure theory. I hope I haven't bored you with this. Thank you.
Thank you very much, sir, for your immensely insightful and extremely informative lecture. We were all spellbound, and I'm sure for many years to come, none of us would be able to forget this talk. Now it is time for question answers from the audience. We have picked up a few questions from the audience. I request Ms. Asolkar to read out the question for the chief guest. Ms. Asolkar. Please. Lily, can you read the questions? Can you read the questions? Handwriting is a problem. If you can, please.
So the first question is, assuming the constituent power by the Supreme Court, to what extent it is justified by a constituent body to have a doctrine like basic structure?
So that's a very far-reaching question, of course. Difficult to answer that in a few sentences, but I'll try. As a country adopts a constitution as a big, major change, usually constitutions come either on independence or after revolutions, or if there is some kind of a coup d'etat, you have a new constitution. It's not a usual transformation of law. If certain elements of that constitution are basic, and the Supreme Court has been defining what elements are basic in broad terms: freedom of speech, judicial review, elections, institutions of democracy. It has not and should not be granular, because you'll have need for a lot of change within the details. If that is what the Supreme Court restricts itself to, then it's doing a service to the Constitution. It's saving and preserving this Constitution. No one stops a country from having a new Constitution. Go ahead and we can get it. It can be something completely different. But that will require a revolutionary change, not a constitutional change. If you want a constitutional change, then these are the essential features within which you have to work, and the Supreme Court is the sole and exclusive guardian of that.
Thank you, sir. Sir, I guess sir has already answered this question, but still, few of the critics, they argue that the basic structure leads to unelected dictatorship instead of an elected dictatorship.
I'm not sure. One thing is clear. One thing is clear. As I said, when I read the Constituent Assembly debates again after a long time, I don't think if you had gone with a basic structure theory to the members of the Constituent Assembly that they would have actually put that into the Constitution, to be fair. But I think it's equally fair to say that in the decades of our existence after 1950, now coming up to 75 years, experience has shown that the basic structure theory has saved our democracy. So as a matter of experience, rather than a matter of pure textual interpretation, I think it's shown that it saves the institutions of democracy. There's no question of our elected dictator, because anyone who's elected functions within the institutions. Every government functions within the institutions of democracy. You may agree, you may not agree with them, but they function within the democratic institutions.
And the third question is also connected to this. It's more about the jurisprudence, whether the result of the trust on the elections to the parliament, or rather the purpose of the elections to the parliament, is not to legitimize the parliamentary power to amend the constitution without any limitation?
I think that's self-evident, because the constituent power is different from the power of every transitory parliament. That I think has been well settled by our Supreme Court.
Thank you so much, sir.
Sir, my question is whether the government of the day to have exalted Article 368 while doing away with Article 370.
That's a more granular point. It could have. It actually could have.
And Advocate Dave says that parliamentary debates, the reading of parliamentary debates shows that it was a basic structure article. It should have
No,
been basic structure.
actually, you're right. You're right, in passing, I'm not saying this is a studied view because it was just in passing. When you read some of the debates, the reason why the members wanted so-called temporary provisions is because they couldn't decide on what the permanent provision was going to be. So they kept it easily amendable. So you can't say any of those are part of the basic structure. They are clearly amendable. You could have resorted to 368. There's another alternative route that was followed. But it could have been amended under 368.
One question I want to ask.
Of course.
It's a bit awkward question, but firstly, I must say that I hope and trust that Keshavananda Bharati would never be reviewed. But suppose review of Keshavananda Bharati is undertaken and you are given choice on which side you will argue. What will be your answer?
So it's a double-barreled answer. You know, as when you get into the practice of law, actually sometimes you find more interesting or challenging to argue the more difficult side. And today in the mood of the country, the more difficult side is easy amendability. Everyone is, I think, broadly of the view that basic structure doctrine must remain. But jokes apart. No, obviously, I think it has stood the test of time. It's been tested, retested, debated, analyzed, critiqued, and the essential elements of Kesavananda are intact. I would only urge one note of caution to the Supreme Court, and I think they've been following it up to now. Don't get very granular in trying to pack everything under basic structure. Everything can't be in basic structure. So only very essential, broad, overarching things must be within basic structure, nothing more than that.
I have a small announcement to make. The students and the attendees are informed that the university has arranged tea after the lecture. Please go and have your tea before you go. Honorable dignitaries, ladies and gentlemen, it is time for now to conclude this program. And to conclude the program, I request our honorable and beloved registrar, Professor Dr. Dhanaji M. Jadhav, to propose the vote of thanks. Professor Dhanaji.
Dignitaries on the dais, of the dais, most valued invited guest, I am standing before you with the utmost humility and great privilege to propose vote of thanks of this momentous occasion. At the outset, I thank Chief Guest and the Speaker of this late ML Pendse Memorial Lecture, Hon'ble Shri Darius Khambata, for accepting our invitation and making it convenient to grace this occasion. Thank you so much for such eloquent and captivating speech. You have really took all of us to the 51 years old judgment of Keshavananda Bharati versus State of Kerala. There are few judgments which remain in the history, but probably Keshavananda Bharati versus State of Kerala has made the history. When we consider that independence of a judiciary is a sine qua non of democracy and rule of law, the constitutional spirit assumed the great significance. You have really interwoven the very dimension and dynamics of Keshavananda Bharati versus State of Kerala. We are really honored by your speech. Recently, one book which was written by Robert Rutland, The Ordeal of the Constitution. When we refer the constitutions as the epic book, this Keshavananda Bharati judgment will be referred really the ordeal of the Constitution. Thank you so much for your address. I must place on record my sincere thanks to Honorable Chancellor, Honorable Justice Abhay Ok, Judge Supreme Court of India, for his constant support and guidance. It is because of his tremendous dedications, university is shaping in terms of administration and academics. Thank you, sir, for your presidential address. I take this opportunity to thank Honorable Justice Ravindra Guge, who is very meticulous with respect to any program, arrangement, meticulous planning, and execution of the same. Thank you so much for your constant guidance, sir. I take this opportunity to thank to Honorable Justice Mangesh Patil, Judge, High Court of Bombay, and the member of the General Council for his esteemed presence. We are really gratified by the august presence of many judges of the Bombay High Court sitting and retired. I must place on record my sincere thanks to Honorable Justice Vasanthi Naik for her generosity and for providing this opportunity and platform for conducting this ML Pendse Memorial Lecture. I'm very much thankful to all the honorable members of the Coordination Committee. I also thanks to the member of the Bar, member of the General Council. I also thank Professor Dr. Lakshmanath, a distinguished jurist, many academicians and the students of law. Last but not least, I thanks to my member of the Coordination Committee for the meticulous planning and execution of this program. I last thanks to all of my students for such warm response. Thank you everyone for being with us. Thank you so much.
We can conclude the program now. Thank you one and all. Thank you so much.